Hey, outdoor legal warriors, a question or an objection that I often get in my office is, hey, if I do classes or I do some type of evaluation in my criminal case, isn't that an admission of guilt? Isn't that going to harm my case? Well, if you're interested in the answer to that question, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 20 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get to see it. More people get the help they need. Now I'm just going to jump right into it. You may know from watching this station about a standard and very effective defense strategy in cases is often to have someone accused of a crime do some affirmative steps, some affirmative educational classes, and an alcohol or drug evaluation, could be a domestic violence evaluation, things like that to sort of improve their negotiating position because it shows someone's taking something seriously. It can also make it easier for a prosecutor to feel part of a solution if a defendant or a suspect is bettering themselves. It can also be very useful for the court when the court's going to make a final decision. If the court is making a decision on an outcome where the outcome is not agreed, if a client has done some things, it puts them in a much better light for the court. And so those are some reasons why it's such a powerful and common method to help defend a criminal case as opposed to just looking at the fact pattern and just saying what they can and can't prove, because one doesn't exclude the other. Or does it? That's the question that we get. We get the question, hey, Lance, if I don't want to do this anger management class because that's an admission of guilt. If I do that, I'm admitting I'm guilty. And that's absolutely 100% wrong. That is wrong. That is false. It makes sense why some people will feel that way because it's very personal. Why should I have to do something if I'm not in the wrong? And that's a fair position to take. Our answer to that typically is you don't need this anger management class. Well, maybe you do, but you don't need this anger management class, but the case needs it, right? And there's actually evidence rules in Washington State that says things like those treatment classes, offers of settlement, things like that, they cannot be used as substantive evidence against you in a criminal case. In fact, it wouldn't even be able to be brought up at a trial. So no, it's not an admission of guilt. And no, the mere fact that you're going to do a class or an evaluation, that is not looked at by prosecutors, by judges as an admission if you're doing anything wrong. Actually, it's looked at as a positive. We don't, in the system, prosecutors and judges don't expect people to go around saying, I did everything wrong, right? People defend themselves. But I do want to cover one of many possible caveats. If you are going to a treatment provider, let's say for a domestic violence evaluation or a sexual deviancy evaluation in particular, make sure you talk to your attorney first, because some of those questions you're going to be asked in that type of evaluation may lead to some type of admission, you saying something that builds some part of a criminal case against you, because they'll ask you to describe what happened and they tell you to be honest. Well, let's say you shoved a door that hit your spouse, and if that's not in the police report and now you say that as part of the evaluation, the mere fact that you have an evaluation, that can't be used against you. But we get a little bit nervous on the defense side if we see relating of the event by the treatment evaluator that's written up an evaluation that has the suspect or the defendant telling their version of the story. And when they're retelling that version of the story, it admits to some things in there that, again, the prosecutor's not going to call the treatment provider to testify, but if it sort of makes us look bad, it's a little harder for us to use that evaluation if the government or the prosecutor reads that closely. So if it's a full DV, domestic violence evaluation, or a deviancy evaluation, make sure that you're talking to your attorney about, what we can say and maybe what we can't say during the evaluation, or a way to say it that is still truthful but doesn't cause problems. I'm not too worried about alcohol and drug evaluations, about what you say there. Usually it's going to be very consistent with what's in the report from whatever the police officer asked during the time of the event. And it's not really looked at in the same way a DUI case is sort of, it's the most scientific and sort of rote type of prosecution, because it's basically the same case over and over again. Driving around, got stopped, smelled alcohol, took a breath test or didn't, took field sobriety test or didn't. There's not much damage you can do in an alcohol drug evaluation that would sort of blow up a case, where it can be in other cases involving assault, all types of assault and things like that. So what other types of evaluations or classes can we do that we really don't need to worry about hurting us? Well, an alcohol drug information school, that doesn't hurt us. A DUI victims panel, a domestic violence victims panel, DVMRT treatment, domestic violence MRT treatment, that doesn't have an evaluation. It's just you go and you do your classes. None of those are very risky. None of those are admissions of guilt. And if you're feeling like, hey, I don't want to do it because I didn't do anything wrong, if our client says that to us, we'd say, we understand. We understand that's how you feel. But we're the ones who know how the system works. If you're hiring an attorney, you're spending your money on that attorney, it's very wise to listen to your attorney. And some other attorneys may have different opinions than my thinking on things. But in my 30 years of doing this, treatment, classes, evaluations is one of the most powerful things that the defendant or suspect can do to improve their position, because otherwise we're pretty powerless, right? The client can tell us what happened, but you're not going to have a chance to tell anyone else what happened unless it gets to a trial, and we like to avoid a trial if we can, because we lose control of the outcome. Then the jurors, the 6 people who couldn't figure out how to get out of jury duty, or 12 if it's a felony, they decide what happened. And, nowadays, jurors want to convict people, in my opinion. Everyone hates everybody nowadays. Everyone's mad at something. This is not an easy time, I think, around. And so let's try to keep control of the outcome and not give away control because we feel like we shouldn't have to do something, or that if we do it as an admission of guilt, it just isn't so. So I hope you found this useful. It's really powerful. If so, please like and please subscribe. More people get to see it. More people get the help they need. And more importantly, if you've got a criminal matter in Washington State, feel free to reach out to my firm. If we get on board, we'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.